panelists. Today, this panel is talking about some of the complexities that arise in litigation when a cross-border conflict is at issue. It's a truism that the capital markets are increasingly integrated, but the litigation of this integrated capital markets still has some wrinkles that we are going to hear about right now. The panelists are Hannah Buxbaum, Schiller Chair in Legal Ethics at the University of Indiana, and also an expert on international jurisdictional issues, and particularly in securities and securities class actions. We'll then hear from Doug Worndl, who's a partner at Siskinds LLP, an expert in Canadian class actions, and he tells me he generally appears on behalf of plaintiffs. And then Larry Lowenstein, partner at Osler, Hoskin Harcourt, who litigated the case that we're going to be, the Canadian case that we're going to be talking about, Kaynes versus British Petroleum. So we'll first hear from Hannah, then Doug, and then Larry. Thank you.
Even though I don't have slides today. So thank you to both the Foundation and the Law School for the invitation to join you today. And I'm looking forward to this discussion of some of the jurisdictional issues behind global class actions. So my job is really just to lay the table for Doug and Larry, who are going to talk about the post-Kaynes prospects for global class actions in Ontario. That case arguably, and I will come back to the arguably part, introduced an approach under which the place where securities are traded is the place that has jurisdiction over resulting claims. So that kind of approach would preclude global class actions by fragmenting the investor group, right, in the case of companies with cross-listed securities. So if it is the place where securities are traded that dictates where a claim can be brought, then investors who traded on NASDAQ would have to sue in a US class action. Investors who traded on the Toronto Stock Exchange would sue here, and so forth. So the US experience on this question is relevant for a couple of reasons. First of all, the Kaynes Court quite explicitly drew on the US approach in reaching its decision. And second, our own move to a place of trading standard happened already in 2010. So we now have a little bit of evidence on what that shift means for investor recovery. So let me start by talking about how Kaynes used the US approach, and how, in fact, in my view, the resulting standard is really very, very different from the U.S. rule on this point. The most surprising sentence in that decision to me was a sentence that said, "Order and fairness will be achieved by adhering to the prevailing international standard tying jurisdiction to the place where the securities were traded." I don't know that there is a prevailing international standard here. I mean, that's an empirical question to which, I have seen no comprehensive study suggesting such a thing. The United States, of course, does have that as a jurisdictional standard. That's what we adopted in our Morrison case in 2010. But if you look, for instance, at what the Netherlands is doing with its mechanism for settlement of multinational class actions, it's going totally the other direction, right? So albeit on relatively unclear jurisdictional footing, the Netherlands has explicitly said, no, it's not based on the location of trade. So I think maybe what the court meant here was that the United States has adopted that standard, and indeed we did, right? So the Morrison decision was a decision about regulatory jurisdiction. In other words, what our Supreme Court said was that the anti-fraud provisions of U.S. securities law only reach claims arising out of transactions on U.S. exchanges or otherwise entered into in the United States. That's a location-based rule, right? I mean, it essentially makes global class actions in the United States no longer possible at all, because our anti-fraud laws are deemed to reach only claims arising out of trading that happened on American exchanges. That is not at all what Kaynes does, right? So, first of all, Kaynes is decided simply on the basis of forum nonconvenience, right? The court, indeed, in the first half of that decision, concludes that there is jurisdiction in Ontario over claims arising out of transactions that occurred in the United States, right? So it certainly does not adopt an exchange-based rule. The most that can be said, I think, is that it adopts an exchange-based philosophy, right, through its reliance on international comity and the idea that in deference to, international everything, right, that the court should refrain from exercising the jurisdiction that it concludes it in fact has over the relevant claims. So, Kaynes was one of those tail wagging the dog kind of cases, right? There was a very, very small group of claims arising out of trading in Ontario and a huge class, right, of claims arising out of trading in the United States and elsewhere. And so, looking at the facts of that particular case, I think it makes sense to say we shouldn't let that small class of local claimants sort of drag this whole big litigation into our courts. But it's not at all clear to me that the same result would obtain in a case where, for instance, half of the investors traded in Toronto and half of the investors traded in the United States. I think that could very well come out differently. Because forum non is, it's one of those malleable, discretionary, flexible standards. It is not so Kaynes again is not, in my view, anything like an exchange-based rule. So let's assume that, again, at the least what the court was saying is that it was adopting an exchange-based philosophy and that it does follow that forward into future cases. What does a shift to a place of trading approach mean for investors, right? So what consequence does that shift have for investor recovery? Here, what's relevant in the United States, I think, is our post-Morrison experience. So we have seen now a little bit of what happens when global class actions are no longer possible, right? And the only investors who can recover in claims in the United States are those who transacted within our borders. So the most obvious and immediate consequence, of course, is that for local investors who trade abroad, they have to sue someplace else, right? So if they are going to assert their claims in a class action, it's going to have to be in some other jurisdiction. That is true regardless of whether or not misrepresentations are made in the United States. Because, again, Morrison is a bright line rule on that front. For local investors, that is to say, U.S. investors who trade in the United States, I think another consequence is that excluding foreign claimants may make class actions less viable economically, right? Because the more you fragment those, the overall group of investors into small localized clusters, the more you run into the possibility that you don't get to the level that it is a viable class action locally, and that would of course impair the right of even the locally transacting investors to recover. I think this dynamic places an increasing burden on the public regulatory framework. In the United States, it is important to highlight, Congress, when it enacted Dodd-Frank, included a provision that legislatively superseded Morrison with respect to public enforcement action, right? So it restored the old conduct and effects tests with respect to public action. I know that there is some debate among commentators on that point. I think the people who say that the legislative fix was not effective are wrong, and I can defend that position in Q&A if anyone has any questions about that little technicality. Okay, so I think the other consequence of a move to, the other consequence in the United States of the move to an exchange-based rule is that it has encouraged private claims based on alternative theories. In other words, claims that are brought not under US federal law, but under foreign law. So we have seen some cases where investors who transacted on foreign exchanges, who are therefore barred by Morrison from asserting claims under Section 10b, have attempted to assert claims based on foreign securities law instead. So I think that the way our courts have dealt with those claims may look something like what would happen post-Kaynes, right? If Ontario courts continue to pursue this exchange-based approach. And the answer is, not so surprisingly, most such claims fail on grounds like failure to meet the certification requirements due to choice of law problems, or indeed foreign nonconvenience, same as in the Kaynes case itself. So, in one sense, having climbed up this hill to explain all of the ways in which Morrison and Kaynes are very different decisions, I'm marching at least halfway back down to predict that the malleable comity-based standard adopted in Ontario, it can certainly be used to foreclose global class actions going forward. I don't think it necessarily has to be used in that way. The way the Morrison approach does necessarily have to be applied in the United States, but I think it certainly leaves room for foreclosing a great number of of global class actions that could otherwise be brought in this jurisdiction. I will stop there. Thank you.
Good morning, and thank you to Osgoode and Fair for inviting me to speak this morning. It had not been my intention to do a dissection of Kaynes and BP. Suffice it to say, from an investor perspective, it's an unfortunate decision, which, in my view, creates more problems than it solves. In the limited amount of time that I've got, I would like to make three principal points. First, in my view, Kaynes was wrongly decided, in part because it was based on incorrect factual premises. And one of them, of course, is relates to the comment by Hannah, and that was that there is some kind of a prevailing international norm or practice which calls for an exchange-based test for jurisdiction and forum. I think that's clearly not the case. Secondly, and quite apart from what I believe to be cracks in its factual foundation, in my view, Kaynes sidesteps the explicit legislative intent of the OSA Part 23.1 regime, which is that it has extraterritorial application. Curiously, the court in Kaynes accepts jurisdiction under Part 23.1, or acknowledges jurisdiction under Part 23.1, but then declines it on F&C grounds. I think that its reliance on comity in doing so was misplaced, and I will try to explain why. Thirdly, and this is dealing with the effects of Kaynes, because the jurisdiction was acknowledged in Kaynes as fundamentally a forum nonconvenience case, it may well be that the exchange-based test won't prevail to determine forum in securities class actions in Ontario. As we all know, FNC is highly contextual, fact-specific. It may well be that in a future court won't place the emphasis on the place of exchange that did Justice Sharpe at the Court of Appeal, but we don't know. And from my perspective, that creates increased risk regarding the viability of a class action, and ultimately undermines the effectiveness of our country.
Yeah, could I interject as the moderator? First of all, for the Americans, you might have already picked up, what we say is forum non in the U.S. and here for forum non-convenience, and here in Canada it's FNC. But also, could you maybe just give one sentence of the facts, factual scenario?
Sure, and that's a good touching off point. I don't have an intimate understanding of the factual basis of Kaynes and the evidence that was presented to the court, particularly regarding foreign law, which seems on the face of the decision to be somewhat problematic. But Kaynes was a case, in my view, where the facts suggest a fairly tangential connection to Ontario. We had a foreign issuer, British Petroleum. It's a UK company based in London. We had some securities traded at some point in time in Ontario, but on the facts of the case, the Ontario traded securities were relatively minuscule. The vast majority of the securities were traded in the United States, at the UK, and I think to a lesser extent Germany, and Larry will correct me if I'm wrong. And although it's not classically an F-cubed case, the kind of case that was Morrison, where you had not only a foreign exchange, a foreign issue, and foreign investors, the class which sought to be certified in Canada were Canadian investors, regardless of where the securities happened to be traded. In a classic F-cubed case like the United States, the investors would also be foreign. They could be foreign, but the traditional conduct or effects test of the United States, which was rejected by Morrison for the reasons stated by Hannah, it was like an F-squared case rather than an F-cubed case, if you want to call it that. And so Kaynes was a case where, frankly, I've got no particular interest in the case. It's not one of my cases, but it's a case where one can understand why the court said this is a case of the tail wagging the dog, and why in the world is this case here in Canada? And that's understandable from a macro or a 10,000 foot level. What's problematic is the introduction of this Morrison test to assess forum nonconvenience in the face of an explicit legislative intent that Part 23.1 would have extraterritorial application. That's my real fundamental problem with Kaynes. So that's the background of Kaynes. And frankly, I don't particularly care about a Kaynes-like scenario where you have a small, very small group of investors in Canada and trying to bootstrap a global class in such a situation. What am I concerned about? I'm concerned about the great many senior cap issuers in Canada that are interlisted and they trade in the United States pursuant to the multi-jurisdictional disclosure system. Under the MJDS, and this applies to a great many issuers, some of our most senior issuers, Bell Canada Enterprises, Suncor, and many others, BlackBerry, I'm told, they access U.S. capital markets pursuant to this kind of most favored nation status, which was granted in 1991 through the MJDS, whereby the Canadian disclosure, whether it's prospectuses, MD&A, continuous disclosure, it's accepted by the Securities and Exchange Commission as adequate disclosure from an American point of view, but it's accepted by the Securities and Exchange Commission without really much scrutiny. There's a wrapper, a very brief form explaining what the nature of the disclosure is, but that's how these large Canadian issuers, in large measure, make their way onto the New York Stock Exchange or the NASDAQ or any other major exchange. Under those circumstances, you can have a very substantial number of shares traded in Canada, but a much more substantial number of shares traded in the United States. And although I would strenuously argue, and when required to argue, that Kaynes ought not to be determinative of whether or not a global class could be sustained in such a case in Ontario, I would be concerned about subsequent trial judges or motions judges simply adopting Kaynes as the test. In other words, you cannot maintain a global class. Ontario TSX traded shares can be litigated in Ontario pursuant to Part 23.1. New York Stock Exchange traded shares should be litigated somewhere in the United States, presumably under 10b-5. I think that is explicitly contrary to what is the intention of the Part 23.1 regime. And to be explicit, more explicit about it, the right of action which is created by Part 23.1 is a right of action against responsible issuers. Responsible issuers are reporting issuers or issuers who have a real and substantial connection to Ontario. And the right of action is accorded security holders of responsible issuers. It doesn't say security holders who purchase their securities on the Toronto Stock Exchange. It says security holders. So we have, and it's recognized by the Ontario Court of Appeal in the Canadian Solar case, that there is this extraterritorial application, and in fact it was recognized by Justice Sharpe in the Kaynes case in assuming jurisdiction, saying that indeed the Ontario regime is extraterritorial in its application, but then he jumps over into FNC analysis and the interest of comity, and on the basis of the so-called prevailing international standard, he says we should decline jurisdiction. And so the problem that I have is, and one thing which Justice Sharpe says in Kaynes, which I think is an important analytical framework, and that deals with the reasonable expectations of shareholders. I would suggest the reasonable expectation of shareholders, the reasonable expectation of issuers should inform where these cases are going to be litigated. And if you've got an Ontario reporting issuer having its annual general meeting at the Royal York Hotel, presided over by directors who are all from Bay Street, administrated by one of our major Bay Street law firms. These cases are quintessentially Canadian, they're quintessentially Ontarian. If I'm an investor, whether I'm placing an order for securities from Markham or Maryland or Mozambique, it seems to me that my reasonable expectations are Ontario law will govern any disputes arising out of the purchase and sale of these securities, regardless of where these securities happen to be traded. So that's my principal concern. There are other, I think, factual, foundational problems with the case, which I'd be happy to get to in Q&A. But where I would like to finish is with an assessment, a very brief assessment of Kaynes and how things are going to be dealt with going forward. As I said, from my point of view, the two main problems with Kaynes and an exchange-based test for form is that ultimately it will fragment class actions, potentially to the point where they are not economically viable, and I think that defeats the purpose. One thing that was not discussed in any meaningful way in Kaynes, which I think is most important, is that the Part 23.1 regime is an integral part of our overall regulatory regime. It was brought in place in order to effect a public interest, to affect a public interest concern, and that is to enhance the enforceability and the effectiveness of our securities law. If these class actions are not brought because they are fragmented between classes of shareholders who traded in Toronto or New York or in London or in Germany or where have you, then that very significant public interest component of this kind of litigation is lost. And just by way of a conclusion, Justice Sharpe said that he was motivated, or the case was motivated by a concern over the avoidance of multiplicity of proceedings and to permit a certain amount of predictability into how these cases are going to be prosecuted. If you move to an exchange-based model, then there is inherently multiplicity of proceedings depending upon how many exchanges the securities are traded on. And as far as predictability is concerned, by dealing with all of this in the context of FNC, as Hannah noted, it's a malleable concept. How are you going to be able to predict whether or not you're going to be able to carry on with one of these cases or not? So those are my comments at the moment. I'm happy to elaborate during Q&A. Thank you very much.
Thank you, and thank you to the organizers for inviting me to be on this panel. I suppose I'll start off by quoting Shakespeare and saying that this is really much ado about nothing. And then I will mix my metaphors, saying that not only should the tail not wag the dog, but when in Rome, we should do what the Romans do. This case, the Kaynes and BP case, did not get leave to the Supreme Court of Canada, despite very able people on the other side of the case, which at least might signal that if the people of the Supreme Court were not already doing their job, they did not see this as having the sort of very dire implications which Doug, in his analysis, is concerned about. And I can see the force of all of Doug's objections and Hannah's as well, but I think that I come out very close to where Hannah is, saying the beauty of the discretionary approach which Justice Sharpe enunciated allows the case to be decided on its facts, and I think the facts are quite unusual and do a lot of justice to what really was going on, because we on behalf of BP never contested the jurisdiction of people who bought over the Toronto Stock Exchange for a limited time during the class period, some portion of the class period. BP, who knew, had this vestigial listing on the Toronto Stock Exchange, which was so little used that it was eventually delisted. So the case takes its inception really from Van Rita in the Supreme Court, and saying, what is the real and substantial connection to Canada? And while Doug says correctly that if you read the Ontario Securities Act literally in terms of its extraterritorial application, I say, well, that's all very well, unless you have to have silent amnesia about the Constitution, which may have some thoughts about the ability of the Ontario legislature to act extraterritorially. So I think the better view is if there's a real substantial connection to Canada, then Ontario starts to have the real ability to adjudicate. So Justice Sharpe, in a case called Curry and McDonald, which many of you know from other contexts, many years ago, made the comment in Obiter Dicta that when Canadians transact securities abroad, they should expect that they will find their remedy, if necessary, in the place where they purchase. And I say that is really little different from when I buy something from, well, my daughters buy it from one of these companies that I'm always getting packages from at my door, or when I buy an iPhone at Heathrow Airport, and I would naturally assume that my remedy lies in the place where I bought it. That's where I'm in Rome, which I should do the global student. And then with respect to Justice Sharpe, I do understand Hannah's criticism that he talked about an emerging transnational standard. And I think that that's perhaps a little bit unfair because it's a fair criticism, but it has the defect of reading the case as if it's a statute. Because for all practical purposes, the case has argued for Sharpe's court was over the border between Canada and the United States. So an emerging rule in our biggest trading partner with a massive North American integrated securities market to some extent, not surprising that Justice Sharpe said the transnational standard of exchange rates rule emanating from Morrison might have been forefront in his mind. But I think in the principle that it emanates, the beginning of his wisdom started from his own statement in Curry, that when Canadians transact abroad, in the Netherlands, then they would expect the Netherlands standard, at least prima facie, to apply. So I see no problem there. I hear the criticism keenly that the philosophy of exchange rates rules is potentially inimical to global class actions. And I say that is the answer to that. I think that Hannah Buxbaum gets to similar places. Let's look at the facts and look at the discretion. And so those of us who argue these cases, Doug included, I think would ultimately agree that really the Canadian cases have got almost all of them right. In fact, I hope my colleagues in the defense bar don't throw guns at me, but I don't know that we got any of them wrong. So, for example, where it's not just the tail, the little Canadian tail, such a vestigial tail that would be listed, is wagging this big dog. Look at Silver and IMAX, celebrated case for the first time, where the dog was really straddling the border. And Justice Van Rensburg, a lot of criticism from the defense bar, but ultimately held the book of the field. She now sits in the book of the field. She was content to let the case go on in Ontario and Doug's colleagues litigated at the same time as it would be litigated in the United States because of the interlisting of the NASDAQ. And that, I think, is a broad-minded and sensitive approach, looking seriously at the best of recovery. What happened was that the U.S. case settled first. And then she was placed in a bit of a corner. What's she going to do? And I think she decided quite admirably that if the Ontario class wanted to opt out of the U.S. settlement, they were welcome to do so, try and get a better case in the in Canada. And guess what happened? They did it. And I think I'm right in saying that the Canadian case settled on similar terms or was discontinued. But that to me is a practical result for inflicting best of recovery. And because this area is so much like three-dimensional chess, one of the dimensions, or maybe even a fourth dimension, that we lose sight of, and I say this hopefully in a fair and balanced way, is the motivation of entrepreneurial plaintiff litigators to get recovery. So a lot of what's going on is the jockeying as between plaintiffs' firms on different sides of the border to get a piece of the action. And that is manifestly, in my view, evidenced by what happened post Kaynes. After the case was stayed, the big bulk of the Canadians who were the putative class had purchased on largely US, but probably to some extent London as well, Frankfurt. Plaintiffs then commenced a case in the US Federal Court of Texas. Guess where the BP Horizon was being litigated? In Texas. and they sought to have the Texas court very recently litigate, to take the case under Ontario law. And Judge Ellison, sitting in the court of Texas, rejected that. We filed Canadian expert opinion evidence in support of our U.S. colleagues. The U.S. filed a brief by Joe Roy, who was counsel for the independent, very knowledgeable counsel, and our side, BP, prevailed. Because what Judge Ellison said is, look, I've already got a class action here. I've appointed a lead plaintiff. And these good Canadians are more than welcome to join the class in the U.S. You know, it's good enough for us to holiday in Florida. I don't know what's the big problem with getting a recovery in Texas. And so the suggestion of you, was any investor ultimately left in the court? I'm yet to meet him. And so what happened was, Judge Ellison ruled that they could go and join the U.S. class, or if they wanted, they could bring individual cases in Texas. Guess how far that's going to go. So what was, I think, the sort of the absurdity which we pointed out about the enormous ambition of the plaintiffs in Kaynes, was that they cast the class as Canadians, which I thought was problematic in and of itself. So if I'm a snowbird lying over the U.S. stock exchange, living in Florida in my retirement, can I then sue over the Toronto Stock Exchange if I like the remedy because I'm a Canadian? And what the hell does that mean? If I'm a Canadian fund manager in transit in Paris and I place the order, who am I? And what's worse, what if I'm a French day trader buying over the Frankfurt Stock Exchange and I like the remedies in Canada? Does that mean that Canada now becomes this safe haven for all investors, even though the thing was only minimally traded in Toronto? Would all investors really think they could find their remedy was done in Ontario if they did some internet searching to what was invested in? And that, I think, is the extremity of the case for the global class action. Rather, I think Silver and IMAX is the appropriate thing in the right case. The case will be allowed to proceed in multiple jurisdictions, see how it happens. So there's some reasonable expectation confined by geography of where you purchased it. I think that makes sense. And finally, I would just say that perhaps the most interesting fact case, Doug's own case in Canadian solar. I didn't find the case surprising at all. Ontario company issued allegedly misleading statements from Ontario, really substantial connection to candidates. It was an Ontario company, what people expect. They chose not to list on Toronto Stock Exchange. They listed only on the NASDAQ. And I think that they got the right result. That I don't even believe there was an existing U.S. case. So there was no forum of non-convenience analysis. You're really going to export these people, largely Canadian dog, to go and litigate in the United States, nothing's going on there. So Ontario is going to apply the remedy for all these people who traded over the NASDAQ. And frankly, I think that if Justice Sharpe, one of our brightest minds, were to look at that case, he would decide exactly the same thing, that the connections are all to Ontario. Ontario has jurisdiction, why should he decline it? Go for it, this Doug is. Thank you very much.
I have a 2-minute reply.
Yeah, I was thinking before we get questions.
Yeah, just very briefly, and thank you, Larry, for your magnanimous comments about Canadian solar, a case before the court, and I'm not going to talk about it any further, but for clarity, there was a competing class action in the United States which was dismissed. But I guess just to reiterate one point, and I hate to sound trite, but you get cases where bad facts make bad law. In my view, there was no need, none, to introduce this exchange-based model in order to achieve the same result that was achieved at the Court of Appeal in Kaynes and BP. And the concern, as I expressed, is not with the international issuers who have, to use Larry's words, a vestigial listing of the Toronto Stock Exchange. The concern is lower courts taking an exchange-based model as somehow a more significant FNC factor in order to break up classes between the different stock exchanges. And my particular concern is with Canadian issuers. And to just make one final point, we all learned in law school, those of us who study securities, that a security is a bundle of rights. And all security holders holding a particular type of securities, common shares for example, have the same rights vis-a-vis other security holders in the same issuer holding the same type of securities. The introduction of an exchange-based model creates diverse interests depending upon where you happen to purchase your securities. Just one other very minor point about the McDonald's case and the idea that, well, if an investor purchases securities internationally, they should be expected to have any claims arising out of those internationally purchased securities to be determined by international standards. One, it necessarily creates multiplicity of proceedings. But secondly, in our modern world with electronic trading, when a particular investor places an order with a broker, acquire me some securities in British Petroleum, acquire me some securities in Bell Canada Enterprises, our rules require the broker to complete that trade on the most favorable economic terms, regardless of what exchange those securities are traded on, and having in mind exchange rates, currency and exchange rates. It may be highly likely that a particular security will be transacted on the New York Stock Exchange, but an investor placing that kind of order with the broker has no way of knowing until the order is ultimately received. So if you are basing your expectation analysis on an understanding that your securities will be purchased in New York or in London, how can that be so when you're not going to find out where your order is filled until after the fact? Those are my final comments.
So just on that point, for the mom and pop trader, where you call your broker and say, buy me some BP, I would expect that as part of the know your client and the fiduciary discharge of duty, the broker would say, look, I can buy it over the TSX or the New York Stock Exchange. Do you want exposure in which currency? So I would expect that would be part of the conversation. In the institutional setting, I would very much expect the sophisticated players would know where they wanted the currency risk. So I think that I'm not so sure that it would just be left to where they were settled. But if you did that, I think you would, in a sense, if you said, I don't care, just buy it on either exchange, I'm indifferent, then I think that the correct legal analysis is that you are taking a risk as to where the case is going to settle. Really, because the BP thing was so thinly traded, and incidentally, that is why my opponents were so keen to try and they had such grand ambitions, because there's not much money to be made out of traded on the Toronto Stock Exchange. Any final point I think is it was such a great discussion that Doug and I had about these exchanges. The value of avoiding multiplicity of litigation is a fundamental litigation value. It's seen in our rules of procedure, presumably in the world, and it's a laudable value. But it's a naive platitude when applied to sophisticated jurisdictions, particularly when you have entrepreneurial plaintiffs who have listed companies. You're going to have litigation on two sides of the order, wherever there's anything that's happening. Look at Valiant. Investigations announced in New York, in Toronto, in Windsor, guess who that is, in Saskatchewan, guess who that is. And so that's the kind of incentives that we've built into the private investor recovery system. So it's left to the courts to arbitrate and rationalize amongst these competing interests. And so what I like about what Justice Sharpe did is he left it to discretionary balancing, which is quite finely calibrated in an individual circumstance. I think that analysis, like he was saying, will come back to haunt me in other cases for the very reasons that Hannah says, because I lost the other part of the argument, which is to say, Ontario has no jurisdiction here at all. Foreign company, BP, issues allegedly misleading statements out of London. And indeed, let's assume that investors relied on them such that damage was sustained in Ontario. If we read Van Brito, literally it says the place where damage is sustained is not relevant, not determinative to the jurisdiction analysis. And where we have reliance removed as a factor for recovery, the fact that there was reliance in Ontario in our argument and the argument of many of the previous cases should not have been a predominating factor. Justice just ran right through that. He said, I don't care. These people got their communications in Ontario. As far as I'm concerned, we had jurisdiction. He just gave short shrift to all this careful analysis that we did of Silver and IMAX, and Solar and Arctic Glacier, all these great cases. In effect, I think he said jurisdiction is easy. Don't bother me with this. The right case will always take it.
All right, so we have a number of questions here, but Professor Buxbaum would like to make one.
Yeah, I want to leave time for questions too, but just a 20-second comment on what Doug said about securities as a bundle of rights. I just want to point out there's another way of looking at this, which is when you buy your security on an exchange in a particular country, the pricing should then incorporate that country's remedies in the event of eventual fraud, right? So I mean, it's that intuition that is underneath the bonding hypothesis and so forth. So, you know, I think there's an argument that indeed there is a reason economically that location of the exchange plays a significant role in these decisions.
The first question is, and this is a question to any of the panelists, which is what rule do you think will apply? Will an exchange-based rule apply in a primary offering, where, as very often happens, if there's a Canadian offering, there's also a concurrent U.S. offering?
The short answer is I don't know. I can speculate. A claim arising out of a primary offering is covered in Ontario by not Part 23.1 but Part 23, which is also a non-reliance based system. So in other words, it doesn't matter whether you read and relied on the prospectus. The fact of the matter is, if you purchase pursuant to a prospectus or in connection with a primary offering, then liability will flow pursuant to the statutory remedy. When we've got cross-border offerings, I mean, let me state my preference, and I think it's a principled preference, and that is there should be a natural. This is further Larry's comment about it's naive to suggest that you're not going to get multiplicity of proceeds in an international securities milieu. It seems to me that there's a natural jurisdiction for these cases to be brought. It is natural for all claims by shareholders, wherever they happen to reside, of a Canadian company regulated by the Ontario Securities Commission, for all of those claims to be brought here. Why? Because the civil liability regime is the product of great stakeholder involvement, a lot of hand-wringing, and a desire to avoid the perceived excesses of U.S. securities litigation. I would say that it's easier to get a case underway here in Ontario, but once a case is underway, then you're going to be subject to liability limits and all kinds of other countervailing factors, which our legislators have decided is in the interest of our capital markets and how they're regulated. So I would suggest that it is far from a foregone conclusion that these cases should be litigated in multiple jurisdictions. I suggest that Canadian claims of Canadian shareholders or Ontario shareholders should be prosecuted in Ontario pursuant to Ontario law. Similarly, I think that that if you're dealing with a U.S. issuer who is all the connections to the United States, I don't know why it makes a whole lot of sense for there to be a separate class action in another jurisdiction. Let me just preface this by saying these are my opinions and not necessarily those of my partners. So I have no idea what you're up to at the moment.
You can't rely on it. I think that's right. I mean, Ontario, for an IPO, I mean, you've got a precision right, which is a very powerful right, and we surprise people next. I don't know the situation you raised. I don't know if it's a 10b5 remedy at all, but I assume it's a similar remedy.
No, we have a rescission right as well in primary offerings in the United States. So the next question is, again, to any panelists, how can investors control where their security is traded in today's capital markets? And I think I would add to that is, are we suggesting a level of sophistication that, yes, you might have with institutional investors, but no, you're probably not going to have with all retail investors?
Yeah, I think we largely covered that, and I think particularly now with the movie where it is, I think where you're going to be trading is maybe a matter of more focused consideration. One little factor okay, I just mentioned that I totally forgotten it. Talk about problematic. The case was actually started in Alberta, and the master refused to issue leave to serve because he said there's no real substantial connection to Alberta. So they talk about parochial.
All right. So if we have, we have 5 more minutes. Some of the questions are referring to topics we've covered. And so I guess what I'd like to ask is, and obviously we can't comment on current litigation, but what are some of the strategic considerations, if any, that we haven't already discussed about litigation in the United States and or Canada?
Can I actually, it's not commenting on current litigation, but commenting on past litigation. So it's true, of course, that there is the particular U.S.-Canada situation because of the multi-jurisdictional disclosure system, because of just the frequent cross-listing of Canadian and American companies and so forth. And I just want to point out there have been a series of cases in which, and you know, some of these predated Morris, right? Cases in which there were parallel proceedings going on, and the courts actually more or less negotiated simultaneous settlements where it was a condition of the approval of the settlement in the United States, for instance, that the investors not pursue remedies in the Canadian class action. So I think there are possibilities for this kind of cross-border cooperation at the settlement stage that could solve some of these conflicts. I also want to make just one comment because it connects to the previous panel on fair funds in the United States. So Osgoode was saying, one of the uses of the fair funds channel to get recovery to investors is to handle the kinds of cases where otherwise there would be no opportunity for the investors to recover. And foreign investment is one of those, right? Because now that Dodd-Frank has restored the ability of the SEC to go after or to pursue claims arising out of foreign trading, they can pursue fair funds recoveries that would then benefit not just the investors who traded in the United States, but also investors who traded on foreign exchanges. And again, there have been a couple. I think there was in the Vivendi case, and I think in the Royal Dutch Shell Transport case, there were the kind of direct settlement that you discussed. Those orders actually encompassed the claims of investors who traded overseas. And again, those predated Morrison, but there's no reason that logic could not be used today. So, I think those are a couple of ways in which there are opportunities for cross-border resolution of these sorts of cases.
I thought I might just supply one more. My introduction to this whole area was we were retained by AIG to litigate, famous local capitalism in Ontario. I thought it was somewhat novel because AIG was never traded anywhere in Canada. And the case was going to be heard in Kitchener, the same place where Canadian Solar was litigated, and we were just ahead of Solar, so we were talking quite a bit to counsel on the case. And so we filed all these, full records saying there was absolutely no real substantial connection to Canada. The Canadians bought this, and you didn't buy anywhere in Canada, and they should find everybody else, and we sought to stay. 3 days before the case was due to be argued in Kitchener, our opponents consented to a stay of the case. That I thought was very smart, and I found it quite enlightening. Because the deal that this public deal was struck was they could wait and see what happened in the US, and their clients could either participate in the US, opt out of the US settlement, or participate as they wanted. And if they thought they could get a better remedy in Ontario, they could bring on this case and then face our argument that Ontario had zero jurisdiction. And as events transpired, the case did eventually settle, actually fairly recently. It took a while, I'm not sure why. This is always so smooth. And essentially the case went away, which leads me to believe that most of the Canadian-based shareholders wisely just took the US deal and headed for the hills. And it was done just a practical cross-border settlement with smart counsel, plaintiff's counsel, thinking they wanted to see them at the table of their clients if it was something they could get from the negotiation, or if it was pursuing and make that decision at the appropriate time, which I assume is what happened.
Well, that's interesting strategic thinking from the plaintiff's counsel. Can we conclude with some of the strategic thinking from defense counsel?
Sorry, were you representing the plaintiff's side?
No, I was really the defense side.
No,
Limited to defend.
it gives us some very good insights into the way strategic plaintiffs
If you want to hear from the plaintiff's point of view, maybe I should pipe in on this. Just in passing, Canadian Solar was in Kitchener because that's where Canadian Solar's head office is. It wasn't because there was some strategic reason to start the case there. But just in terms of pursuing a case, we do an assessment. And it is entrepreneurial to some extent, but also having regard to the broader public policy focus of the Act, because it's ultimately going to inform how the court decides or how the court will interpret the various provisions of the Securities Act. But the three fundamental questions, as in any case, are liability. What's your prospect of success in establishing liability? What are the potential damages that can be proved, and what are the prospects of collecting on those damages? Within those three broad frameworks on the liability side, what is desirable about the Ontario regime is it is a no reliance regime, and also there is deemed loss causation. It's rebuttable deemed loss causation. So in other words, if on the public record it can be established that there was a misrepresentation and a market correction, then you are in a sense away to the races. And the demonstrated market correction will be the presumptive damage in the case, unless the defendant can provide reasons as to why those presumptive damages ought not to apply. On a negative aspect of the Canadian regime are, of course, the liability limits. Their recovery or damages against an issuer are limited to 5% of its market capitalization, which necessarily immunizes the smaller issuers from any liability, civil liability at all under Part 23.1. It's simply not economical to pursue a junior cap issuer with a $50 million market capitalization. And I think that that's a real problem. But so in determining whether or not you're going to proceed with the case, you're going to consider these factors and come to a conclusion as to whether or not you can economically prosecute the case and get a result for the client. The Kaynes and BP adds an additional risk factor in that particular assessment, which on a marginal case, plaintiff's counsel may well say, you know what, I'm going to take a pass on this because if Justice Sharpe's determination on a market-based test means that American shareholders are not going to be part of this particular class, well, then it may not be economically possible for us to prosecute the case. I'm saying that, I've said earlier that I'm confident and hopeful that in subsequent cases, the courts are going to take a broad-based view of Kaynes and the fact that it's an FNC case and consider all of the connecting factors of which the place of the trading of the securities is only one. So I think we're over time. Thank you.
Yeah, thank you very much. And let's thank